no English whatsoever, putting himself through law school and really dedicating his life to mentoring students and making sure that as part of the HBA that this Moot Court program succeeded and carried on. So here we are, another year, carrying on his legacy. And we thank you so much for joining us today. Now, we started this competition yesterday with 26 teams. These two teams right here, I cannot per the rules tell you who they are or what schools they're from, but they have now competed through 4 rounds, 2 preliminaries, 1 quarter, and 1 semi, to beat out 24 other teams to get to this position right here. So congratulations to both of them. Of course, we wish you the best of luck. We have a very esteemed panel for you today in our final round. The final round is going to be 3 Supreme Court justices who, in just a moment, when the bailiff calls around to order. I do want to thank the HBA for hosting this competition as part of the Corporate Council Conference here in Las Vegas. Incredible conference so far.
Yo tampoco escucho.
We're going to be giving out $70,000 in scholarships. We have a lot of money, a lot of prizes to give out, and we want to thank the HBA for that. Of course, throughout the competition, you've had an opportunity to meet Naomi and Alan, who have been instrumental in helping us run this competition. And of course, my partner in crime, Judge Leonardo Castro from Minnesota, who I could never run this competition without. So we are very grateful for all of the volunteers who helped put this competition together. We're grateful for the HNBA judges who travel all across the country to be here to experience for our students. And of course to the president-elect, and Carla Martin, Director of Programs, who worked tirelessly. We started in June to put this competition together for everybody. So we thank you all and the Las Vegas judges for taking all the time to be here for our students and give them this unbelievable opportunity. So let me just explain.
Excuse me, can you put yourself on mute?
I'll live stream exactly how this is going to work. We have 2 teams. We have a petitioner and we have a respondent. They are going to be arguing a case that is currently pending before the United States Supreme Court. Each side will have 25 minutes and the petitioner gets up to 5 minutes to reserve for rebuttal. Once we're done with the round, we're going to ask the justices to step out of the room so that they may finish filling out their score sheets. And then once they do that, we'll bring the justices back in and we'll proceed with the critiques at that point. So I want to wish both of you much luck and congratulations for making it this far. Before I have the bailiff commence the round, I do have my family watching. They make a lot of sacrifices for me to be able to do this competition. So I want to thank my husband, my daughter, Sammy, and Abu and Nana. I love you all very much. And thank you so much for being here, for supporting me through this. It really means a lot to me. So, all right, without further ado, let us commence the final rounds of the 31st annual Uvaldo competition. And I turn to our bailiff, Carlos. And Carlos, I ask you to please commence the round.
Carlos,
All rise. The Honorable Chief Justice and the Associate Justices of the Supreme Court of the United States. Oye, oye, oye. All persons having business before this honorable court, the Supreme Court of the United States, are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court.
Thank you very much. Please be seated, everyone.
Amorcito, te compré la tortita de pescado.
Okay, this is the time set for oral argument. Are we prepared to proceed?
No.
Good afternoon, Your Honors, and may it please the Court. My name is Ariel Eldridge, and along with my co-counsel, Maria Elise Escobar, we represent the petitioner in this matter, the state of Hamilton. Petitioner respectfully requests 1 minute for rebuttal. This case is about preserving the statutory bounds set by constitutional and legislative protections to ensure competitive fairness in sports. In a moment, my co-counsel will explain how the Hamilton statute does not violate the Equal Protection Clause. But first, I will address how the statute is consistent with the requirements of Title IX. The state respectfully requests that this court reverse the lower court and find that the state acted within the bounds of Title IX for 3 main reasons. First, the statute does not discriminate on the basis of sex. Second, the state does not treat RS worse than other similarly situated students. And finally, RS has not suffered legally cognizable harm. Turning to the state's first point. Title IX prohibits sex discrimination and federally funded educational programs and activities. In interpreting statutory terms, courts frequently look to the ordinary meaning of the text at the time Congress enacted the statute. This court affirmed that principle in NCI Telecommunications Corporation and in Fitzgerald. In NCI Telecommunications Corporation, this court held that the most relevant time for determining a statutory term's meaning is when the statute became law. Here, the state of Hamilton is not discriminating on the basis of sex because gender identity is not included under Title IX.
But doesn't the Grimm case say that they've already held that gender identity is discrimination on the basis of sex? That's the Ninth Circuit case.
Your Honor, the 4th Circuit in Grimm did hold that. However, the 11th Circuit in Adams also held that sex as defined in Title IX was sex at birth, not gender identity. And that brings the state back to this court's precedent in Fitzgerald that the original meaning of sex when Title IX was enacted was understood as distinctions between individuals assigned female at birth and male at birth. And that reflected in dictionary definitions from 1970 to 1980, including Black's Law Dictionary.
Doesn't the statute also discriminate based on sex assigned at birth, as you say, by forbidding transgender girls but not transgender boys from participating in teams consistent with their gender identity?
Your Honor, the state is not discriminating on the basis of sex because the Title IX regulations, as reflected in 106.41b, expressly provide that sex-separated sports can occur when competitive skill is at issue. And here, the state is not adding any new restrictions to Title IX. Rather, it is categorizing students in accordance with Title IX. It is simply doing what the regulations allow. This court in Virginia recognized the average physiological differences between individuals assigned female at birth and individuals assigned male at birth. And Senator Bayh, on the congressional record, also acknowledged that those average differences were a driving force behind having the regulations have the express carve-out for sex-separated sports.
But because the statute categorically excludes transgender girls from playing in women's sports, irrespective of their athletic ability and lack of any identifiable athletic advantage when on hormone blockers, doesn't it meet the statutory definition of discrimination under Title IX?
No, Your Honor, it does not, because as reflected on the record at page 572, RS is not excluded from all sports. And importantly, it's also noted on the record at page 566, swimming involves a competitive skill. Thus, in the interest of maintaining competitive fairness and creating equal opportunity in sports, the state is allowed to have sex-separated teams. Further, in the Journal of Strength and Conditioning Research, a 2022 study found that before puberty, boys outperformed girls in measures of strength, agility, speed, and endurance.
So that was an interesting point from my perspective. Does the hormone therapy that RS was involved with affect your argument in any way?
No, Your Honor, it does not, because the state has to account for all students within the state. This court in Rodriguez acknowledged that the traditional power rests with the state to regulate education. The state agrees that it would be intrusive to have to continuously monitor RS to ensure that she remains on her hormone therapy or on her puberty blockers, and the state is not going to have to subject RS to those intrusive procedures, and that is why the statute operates as it does. Further, the basis for sex-separated sports is well established, but how those differences manifest as to transgender girls is still evolving. And this court in Gonzalez recognized that state legislatures have wide discretion to pass legislation when the science is uncertain. This court said that it would be too demanding of a standard to require states to wait until the science is certain. Thus, Hamilton is able to act when that science is uncertain to ensure equal opportunity.
So isn't the statute doing exactly to RS what is contemplated to be protective legislation under Title IX? So, for instance, that if she was forced to participate as a transgender female on hormone blockers on an all-male team, because that would be her only option at this point under this law, wouldn't she be exposed to physical injury, unfair competitive advantage, all the things that Title IX is supposed to protect?
Your Honor, that brings the state to its third point that RS has not suffered harm here. The state maintains multiple pathways for RS to participate in sports, as noted in the record at page 573, thus there is no harm. She is able to compete on the co-ed team, as noted in the record at subsection C of the Hamilton statute. And before this court can find that harm has even existed, the court must first find that RS is similarly situated and is treated worse than other similarly situated
Well,
students.
that's been how the emotional and dignitary harm is legally cognizable under Title IX, correct?
Your Honor, that was the Fourth Circuit inquiry, correct?
Okay, so we recognize that as a harm, and if RS has to present herself as a boy when she has been living her life as a female to participate on boys' teams, wouldn't that wholly undermine her treatment protocol for gender dysphoria? Would it disrupt her gender identity in every other facet of her life?
Your Honor, it would not, because as noted on the record at page 573, she can compete on co-ed teams, which does not require her to live differently from her gender identity. She could still participate in school and in sports as a girl. And this court stated that emotional harm is not enough under Title IX to result in a violation. In its decision in Cummings, this court recognized that emotional distress damages are not available under spending clause legislation like Title IX. Therefore, emotional harm is insufficient to establish a Title IX violation in this case. And to Your Honor, to Justice Lee's concern, RS is not experiencing discriminatory treatment here because she is not being treated worse than similarly situated students. As noted in Grimm, the Fourth Circuit held that an individual must show worse treatment. Here, the relevant comparator group is other transgender girls, and RS is not being treated worse than other transgender girls. As noted in the record at subsection C2 of the Hamilton statute, all students are treated the same if they are assigned male at birth and if they are assigned female at birth. Thus, there is no unequal treatment under the statute because both sexes are treated the same.
You gotta move, Bobby.
Your
Get it back.
Honor,
Move.
the
Not
federal
slow.
circuits have
Move.
also
Bye-bye.
recognized that
Bye-bye.
tangible
Move.
harm needs to be found, such as educational or financial.
Because you're
The
not
court will be
moving.
presented with a different scenario if RS cannot participate on any team, meaning she couldn't be on the girls' team, the co-ed team,
Alex.
or the boys' team.
Can you
was a
mute
very
yourself?
different set of facts where there could be harm found. However, here, where RI still has multiple pathways to play, as noted on the record at page 563, there is no Title IX violation. Meaningful access to sports under Title IX does not guarantee placement on a particular team, just as long as there is access to sports, which RS still retains. Therefore, for these reasons, because the statute does not discriminate on the basis of sex under this court's precedent, and because Bach is inapplicable because this court recognized in Jackson that Title VII is different from Title IX, and because RS is not similarly situated to other students and is not being treated worse than other similarly situated students, and because she has not suffered legally cognizable harm under Title IX, the Hamilton statute passes the Title IX test and can be found to not be in violation of Title IX. Therefore, the state respectfully requests that this court reverse the lower court and find the Hamilton statute to be in comporting with Title IX. Thank you very much, Your Honors.
Ya lo cogí, va a hablar ella. Ya lo cogí, va a hablar ella.
Good afternoon, Your Honors. May it please the court. My name is Mahelisa Sawat, and I represent petitioner, the state of Hamilton. Petitioner respectfully requests that this court reverse the decision of the 12th Circuit and find the Hamilton statute to be constitutional under the Equal Protection Clause of the 14th Amendment. This case is about maintaining the long-standing equal protection jurisprudence set by this court that allows states to preserve competitive fairness in sports. This court should find the statute to be constitutional for two main reasons. First, the statute survives rational basis review because it is rationally related to an important and legitimate state interest. And second, even if this court were to apply a heightened level of scrutiny, the statute imposes a permissible sex-based classification. Turning to the state's first point, this court has consistently held that state legislation is generally presumed valid if rationally related to a legitimate state interest.
But unless, right, the law contains sex-based classifications, and if it was intended to discriminate against transgender girls, arguably. So, isn't transgender status a sex-based classification, and that it is impossible to discriminate against a person for being transgender without discriminating against that individual based on sex?
Your Honor, the state would disagree with that. Here in the record, as per page 563 and 575, respondent claims that the statute targets her for her gender identity, specifically her status as a transgender girl. This is not a constitutionally protected class, and thus rational basis review is appropriate. This court has not expanded the classification in 40 years. And just last year, this court in the United States versus Penny had the opportunity to rule on whether this classification on gender identity triggered a higher level of scrutiny, but declined to. Transgender individuals are not a quasi-suspect class.
But this Karnofsky versus Trump in the next circuit.
Strawberry and mango?
Your Honor, that court found that they are, but I would implore this court to apply the test it decided in Frontiero 5 decades ago, which applies 4 key factors to make the determination. First, the history of discrimination against this group. Second, the immutability. Third, political powerlessness. And fourth, it treats relevance the ability to contribute to society. It is important to recognize this is a conjunctive test, and transgender individuals fail on at least 2 factors. First, as towards the immutability characteristic,
Gender identity is fluid and therefore does not fall under the standard of ascertainable at birth that this court has applied to other quasi-suspect classifications such as race, sex, and alienage. As seen in the record at page 563, respondent was diagnosed with gender dysphoria when she was 8 years old. For transgender individuals, that diagnosis may come at any age, going against the immutability characteristic. Turning to the political powerless factor, transgender individuals also fail. As stated by Justice Barrett in her concurrence in Spermetti, notable success in convincing lawmakers to address issues related to transgender individuals negates the political powerless factor. Further, there is representation of transgender individuals in Congress, and transgender individuals have the same access to the democratic system.
Okay, so let's assume though that we're going to apply the non-rational basis standard, but we're going to apply the intermediate scrutiny. What is the government's interest that is being promulgated by this law?
Yes, Your Honor, that brings me to my second point. The state here imposes a permissible sex-based classification because of its interest to ensure competitive fairness.
But what evidence do you have that transgender girls who are on hormone blockers create competitive advantage over cisgender girls? What evidence do you have of that?
Your Honor, the state puts forth various studies. According to the National Institute of Health, transgender girls will only achieve a slightly shorter height than their genetic potential, and regardless of their puberty or hormone treatments, athletes assigned male at birth have larger lungs, giving them higher aerobic capacity and ventilation. Further, the Women's Studies Policy Group in 2022 found that swimming records that showed boys in the 10 and under group were on average faster for 100 yards. This study directly speaks to children before hitting the 10 or stage 2 of puberty. The Journal of Strength and Conditioning Research in their 2012 study found that before puberty, boys outperform girls in measures of power, strength, agility, endurance.
What do you say though to the majorities holding in this case the 2-1 that there was an expert affidavit that was presented by your opposing side, and that expert affidavit went uncontroverted on summary judgment, and therefore they based their grant of summary judgment on their affidavit as unopposed. Procedurally, could you comment on that and how that fits with the studies and reports you're citing?
Yes, Your Honor. As per the statute in subsection N, the findings of inherent physiological differences between the sexes are based on the legislative findings. There's nothing in the statute that refers to exactly what studies were considered. However, there's a plethora of research that demonstrates that physiological difference.
Does it matter whether we adopt rational basis or intermediate scrutiny in terms of the deference we would pay the legislative findings in this statute?
No, Your Honor, regardless of the level of scrutiny that this court decides to apply, the statute still survives and is constitutional. This court in Michael M. held that a statute does not violate equal protection simply because it applies unevenly to the sexes. What matters is whether the distinction serves a practical purpose.
Well, so one of the purposes that was articulated is to provide equal opportunities for women, correct?
Correct.
Okay, so what is the substantial relationship or nexus between excluding all transgender girls from all girls teams and providing equal opportunities for women?
Your Honor, if I could clarify the state's interest, would not be to exclude transgender girls, but to exclude all athletes assigned male at birth. And that is directly tied to this court's long-standing recognition of that interest. Ninth Circuit legitimized this interest 4 decades ago in Clark. where a policy excluding athletes assigned male at birth from participating on a girls' volleyball team was substantially related to redressing past discriminations against females in athletic programs. The Equal Protection Clause.
Talking about the competitive advantage, that's really what we're talking about, okay?
Correct, Your Honor.
And to the extent that this protects or purports, the statute purports to protect that. I'm not exactly sure if it doesn't favor cisgender athletes versus a transgender. Is that accurate?
Your Honor, the statute seeks to protect competitive fairness for athletes assigned female at birth. This is directly related to the state's interest. It survives rational basis and survives intermediate scrutiny because of the legitimized state interest and the permissible sex-based classification that this court has held to be permissible. Regardless of scrutiny level, RS is being provided equal protection in sports because the statute treats transgender girls alike. As declared by this court in the city of Cleburne, the Equal Protection Clause is essentially a direction that all persons similarly situated should be treated alike. Thus, to show an equal protection violation, the individual must put forth persons materially identical to them who have received different treatment. Petitioner agrees that RS is not similarly situated to cisgender boys. However, she is also not similarly situated to cisgender women. The appropriate comparator here would be other transgender girls who, like RS, were assigned male at birth but identify as female.
But also taking hormone blockers and other treatments to keep her Tanner 2 stage puberty from manifesting itself, right?
That is correct, Your
So
Honor.
that's even more specific group.
That is more specific, but the state puts forth a statute that is workable for the state. If the state were to, as you mentioned, Justice Lee, narrow the statute, it would be a slippery slope in terms of creating an opportunity or creating a situation where the court would have to become a medical tribunal and would even have to apply and impose medical testing on every student, which could actually put forth an equal protection violation. Or if the court were to go a different way and say that the state had to be broader in its definition of classifications, that would then put the state in a position to disregard not only its own interest in competitive fairness, but an interest that has been legitimized by this courts and circuit courts across the country for decades. Here, under the Hamilton statute, all students who are assigned male at birth, both biological boys and transgender girls, are prevented from participating in sports designated for athletes assigned female at birth. This thus enacts equal treatment rather than invidious discrimination. This case is about maintaining the long-standing equal protection jurisprudence set by this court that allows states to preserve competitive fairness in sports. Thus, petitioner respectfully requests that this court reverse the decision of the 12th Circuit and hold that the Hamilton statute is constitutional. Thank you.
Thank you very much. Counsel, are you ready to proceed?
Chief Justice, and may I please the court. My name is Trevor Johnson, and I, along with my co-counsel, Isabel Otero, represent the respondent, RS. My co-counsel will address equal protection, while I will address Title IX. First issue before this court is whether the state of Hamilton violated Title IX by discriminating against transgender individuals on the basis of sex. This court should affirm the 12th Circuit's decision for the following two reasons. First, discrimination based on gender identity is discrimination on the basis of sex. Second, RS is similarly situated to biological women and suffers legally cognizable harm. The Hamilton Statute, section 90-2-15, states in part that all athletic teams will be designated as male, female, or co-ed based upon biological sex at birth. Further stipulates that female designated teams will be closed to biological males, where selection is based upon competitive skill or contact. However, no comparable exclusion exists for male designated teams. Moreover, Title IX, a state violates or educational institution violates when it engages in discrimination on the basis of sex, resulting in denied benefits, exclusion, or unequal worse treatment. This case is about a 12-year-old girl wanting to play on her school swimming team. Yet, the Hamilton statute bars her from doing so unjustly.
Well, in the past, we've not held that all laws that treat males and females differently are necessarily unconstitutional, right? In the case of Michael M., with the statutory rape only applying for offenses against women and not men, we held that that's because there are inherent differences between the sexes. Why doesn't this statute, Hamilton statute here, comport with that kind of that framework?
Your Honor, because the Hamilton statute is discriminating against solely transgender girls and not transgender boys, which the petitioner incorrectly stated is being treated as an equal group, in which they are not. It solely targets the desperate group of transgender women.
What do you do with the fact that when this statute was enacted, there was no conversation at all about transgender, and it was assumed that sex was determined at birth? And so we're interpreting the statute according to the meaning that it had at the time it was enacted.
Well, Your Honor, at the time it was enacted, it was 1972, and nearly 4 years prior, in 1968, was Stonewall Rise, which was firstly pioneered by a transgender woman. And in the present day, we look to this court, which held Bostock versus Clayton County, that it is impossible to discriminate against transgender individuals without discriminating against them on the basis of sex. So gender identity is read into Title IX's protections against discrimination. That's why the discrimination based on gender identity is discrimination on the basis of sex. As the Hamilton statute attempts to hide behind the Javits Amendment to Title IX, which states that sex-based distinctions are allowed where selection is based upon competitive skill or contact. However, the Hamilton statute goes a step further because it defines eligibility solely on biological sex at birth, a distinction that makes it impermissible as it discriminates solely against trans girls, as stated. Further, the statute and the Javits Amendment does not define what competitive skill is. Seemingly, it could be any sport, from that of swimming to that of chess. And as Title IX's purpose was to expand and not restrict opportunities, this creates the Hamilton statute as a categorical ban on all transgender girls, as Justice Lee has pointed out to the petitioner. And the Hamilton statute.
I would also like to point out on the other side, it doesn't really ban her from playing in school sports, right? It just designates on which team she's allowed to play for, right? She's still allowed to try out for the boys' team.
Yes, Your Honor, but that forces her to be on a team in which her gender identity is not conformed. And RS has spent her entire life from the age of 4 years old going through social change, through legal change, from getting her birth certificate changed to reflect her gender identity and her name, to physiological change.
Does Title IX protect gender identity, or does it protect biological sex?
Congress has never defined what it meant by sex under the statute. However, this court states it's impossible to discriminate against transgender identity without discriminating on the basis of sex. So logically, Title IX protects gender identity. And this same reasoning, textually, has been used in the Fourth and Ninth Circuits. seemingly in the case BPJ versus West Virginia State Board of Education, which is eerily similar to this case. As in that case, BPJ, Becky Pepper Jackson, was a middle school student who tried to try out for her women's track and field team, who also had transitioned at an early age. However, due to West Virginia's State Women's Sport Act, it prohibited her from participating on this team. And as the Fourth Circuit correctly held in that case, that it was a categorical ban, which was treating trans individuals distinctly and discriminatorily, it was impermissible under Title IX. Therefore, as the Hamilton statute is impermissible because it discriminates textually on the basis of sex and categorically bars trans women like RS from athletics.
That Congress is reserved to the states the power to regulate within the education system. And if they wanted to implement something that was a mandate to say that transgender females must be allowed to play cisgender girl sport, wouldn't they have expressly stated so in Title IX? I mean, it's been around for a long time. They haven't amended it.
Why the legislation would choose not to amend it is not take away from the purpose that discrimination does not give a state this does not give a state license to discriminate against its citizens, which are in direct violation of Title IX. This turns to the second point, in which the statute is facially discriminatory, as Justice Lee has also pointed out. It treats all trans women the same as a monolithic group, and it groups together those who have undergone Tanner 2 stage development and those who have not undergone Tanner 2 stage development. An example would be the case of Leah Thomas. Leah Thomas was a college athlete who, after undergoing Tanner 2 stage of development, had transitioned to a female and competed in sports. This is drastically different from the case of RS, who has now undergone Tanner 2 stage development, and as the petitioner has conceded, and the state has conceded on page 568 of the record, those who have not undergone Tanner 2 stage development are similarly situated in this case, like RS, to that of a cisgender counterparts.
And you base that on the affidavit or the expert report in the record, or what do you base that statement on?
Your Honor, that's based on the example of Leah Thomas and the expert testimony also noted on page 568 of the record.
Do you think it's appropriate for the district or for the Court of Appeals to have granted summary judgment based on a failure to produce evidence in opposition on the expert issue of the athletic capabilities of somebody like RS who's undergone puberty suppression drugs?
Your Honor, I believe that it would not be improper for the 12th Circuit to have granted summary judgment purely on the fact that the respondent gave expert testimony who weighed greatly in favor of them and the petitioner did not. However,
What do you do with all the legislative findings that were made in support of the statute by Hamilton? Should we just disregard those as of no consequence to that determination?
no, Your Honor, it is of consequences as those cases were presented, and they were presented properly. However, when looking at the totality of the circumstances of this case, the textually discriminatory use of the Hamilton statute, as well as the injury that RS faces both emotionally and financially, the 12th Circuit should have granted summary judgment in favor of the respondent.
So you're pointing to that as tangible damages, is that correct?
Yes, Your Honor. And as the statute further does not give different treatment to all transgender individuals, as it has no comparable exclusion for boys, it is as well facially discriminatory as it again targets solely trans girls in athletics.
Now, do you agree that RS could just stop taking her hormone blockers at any time, right?
Yes, RS could.
And then would the state then be charged with the burden of having to monitor and regulate the status of her puberty?
Your Honor, the state would have to do the same testing it does on all its students which attempt to play in any athletics, which is that physical and regular testing, such as non-nutritionalist drug testing, which are allowed for by all states. And as the central harm that Title IX targets is exclusion from, denying benefits, or unequal worse treatment, being barred from participation is a harm that those like RS continually suffer by being forced to participate on teams which do not align with their gender identity. And as the state conceded in page 572, 573 of the record, forcing RS and those like RS to participate on teams where their gender identity does not match constitutes gender dysphoria and adds to the emotional harm that she suffers. Further, the petitioner conceded Graham versus Gloucester County School Board and Fourth Circuit held that emotional harms were real, non-speculative injuries which constitute a legally cognizable injury under Title IX. And as RS is not only harmed by what she can do, she's harmed by what she can't do. As by forcing her to play on co-ed teams requires her to affirm that her gender identity is somehow false, and that she's being forced to identify as a male when she's not. As she spent, again, her entire life from the age of 4 and now the age of 12, ensuring that she is
She can still express her gender identity and play on a boys' team, couldn't she?
Your Honor would still require her under the statute to identify as a biological male, which is.
It doesn't say that she has to identify as a male, she just says she has to stay on a male team.
Yes, but to do so, she would have to acknowledge that she is a biological male at birth, which she has sought to undo through legal processes in the state of Tennessee. For foregoing reasons, this court should affirm the 12th Circuit's decision. Thank you.
Thank you, Mr. Johnson.
Chief Justice, and may it please the court. My name is Herrara, and I also represent the respondent, RS. The second issue before this court concerns the 12th Circuit holding that the Hamilton statute violates the Equal Protection Clause of the 14th Amendment. That decision should be affirmed for the following 2 reasons. First, the statute is subject to intermediate scrutiny because it classifies on the basis of sex and because transgender individuals are a subset class. And second, the statute fails intermediate scrutiny because its classifications are not substantially related to the government's important interests.
If we were to apply rational basis scrutiny, do you think that you would be able to get over that threshold?
Yes, Your Honor, because there is no rational reason for discrimination. Turning to my first point, the 12th Circuit correctly concluded that the Hamilton statute was subject to intermediate scrutiny because it classifies on the basis of sex for the purpose of discriminating against transgender girls and because transgender individuals are a subset class. The Equal Protection Clause of the 14th Amendment bars states from denying any person within its jurisdiction the equal protection of the laws. Although the most legislation does classify for one purpose or another, when these classifications target a suspect class, quasi-suspect class, or burden a fundamental right, they are subject to heightened scrutiny.
What do you do with the fact that, and I think that this is established in the record, that transgender person can shift and go back and forth? So it's not an immutable characteristic in the traditional sense for suspect class analysis.
Yes, Your Honor. However, this court does not only consider immutability when assessing if a class is suspect. This court considers, 1, whether a class has historically been subject to discrimination, whether a class has characteristics that impact their ability to perform in society, whether a class can be a discrete group through being a minority, and whether a class is politically powerless.
Here, transgender individuals have historically been subject to discrimination. As according to a bare desire to harm transgender individuals and the Equal Protection Clause, a law review article, when being transgender was considered a mental illness, it was barred from coverage under the Americans with Disabilities Act. Further, according to the National Transgender Discrimination Survey, transgender individuals suffer from higher rates of economic instability, homelessness, and discrimination. Transgender individuals also have no relationship between being transgender and their ability to perform in society, as noted by the American Psychiatric Association. Further, transgender individuals are politically powerless, as the Fourth Circuit correctly found in Graham versus Gloucester County that transgender individuals are underrepresented in almost every branch of government. Further, the Fourth Circuit in Graham also found that being transgender is as immutable as being cisgender, for individuals who are transgender do not have a choice to be so. However, even if this court did not find that transgender individuals are subset class, the statute would still be subject to intermediate scrutiny because it classifies on the basis of sex for the purpose of discriminating against transgender.
But was her main argument that statute targets her on the basis of her gender identity rather than sex? And didn't we learn from U.S. versus Fermetti that just merely saying the word sex in the statute doesn't trigger a heightened scrutiny, right?
Yes, Your Honor. However, this is not a mere reference to sex, as the statute explicitly utilizes biological sex to create categorizations. Further, this court held in Bostock versus Clayton County that discrimination on the basis of gender identity is discrimination on the basis of sex. And here that is shown because RF, if she was a biological female, she would be able to play with her cisgender peers. However, because she is biologically male, she is not permitted to do so. That in itself is discrimination on the basis of sex.
If we accept your premise, which is that the Hamilton statute impermissibly defines sex for purposes of sports as your biological status at time of birth. So you're saying they can't draw that distinction and support it with the findings in their statute?
But Your Honor, rather that distinction is not substantially related to the government's important interest, as it bases its findings off of merely biology and anatomy, rather than driving factors and differences such as testosterone and muscle mass. However, here there is discriminatory purpose, as a discriminatory purpose is shown when legislation is enacted for the negative effects that it has on an identifiable class. Further, this court has emphasized
their view is the state's view, and we're supposed to defer to the states to some extent. How much is obviously an issue here, but their view is they are protecting individuals who were born biological females from unfair competition and even injury in contact sports, which I understand is not an issue here, but the state has a different view. And to what extent should we get in the middle of that?
Well, Your Honor, the state relies on overbroad generalizations that treat transgender girls who have not undergone cancer stage puberty as biological females who have, or biological males who have undergone cancer stage puberty. Thus, that is an impermissible broad overgeneralization. Further, the Ninth Circuit in Peacock versus Little found that a nearly identical statute to the one at hand violated the Equal Protection Clause, because although it classified on the basis of sex, the Ninth Circuit found that the statute's animating purpose was to target transgender individuals.
But if they comparator here, other biological boys who self-identify as female, and doesn't the law here apply to all of those people the same?
Other biological males who identify as female, Your Honor?
Right, so that's the comparable group we're talking about right now, right? So this law doesn't discriminate against transgender females because this law treats them the same as every other transgender female, right? They have to play in the boys team.
Well, Your Honor, that's not the comparison here. Rather, it would be that the state signals out and
disparately impacts transgender girls because only transgender girls are affected under the statute. As transgender males would be allowed to play with those whom they identify their gender with, but those like RS who are transgender girls cannot. Turning to my second point, the statute fails intermediate scrutiny because it is not substantially related to the government's important interests. A statute only satisfies intermediate scrutiny when its classification.
You would agree that a male who was born male biologically at time of birth was identified that way. That person couldn't play on the girls' team either, right?
Well, Your Honor, if they were transgender, they should be able to if they don't have the driving levels of testosterone that differentiate male from female.
So, but you misunderstood me. I mean, you're drawing classes and classifications. You would agree that it is permitted that a statute says only that a person who's born male at birth cannot play on a women's team. Do you agree with that?
That is permissible, Your Honor?
Yeah.
In this context or in general, Your Honor?
In general.
Well, Your Honor, it depends on the statute. As here, it would not be permissible because it creates overbroad generalizations that signal out transgender girls and treat transgender girls like biological males who have not undergone one or two stage puberty. As here, and as the petitioner conceded on page 569 of the record, the driving differences between the sexes are circulating levels of testosterone. And according to page 572 of the record and 563, RS has been on these puberty blockers since the moment of at the outset of puberty. Further, she also takes estrogen hormones, which will allow her to develop the same pelvic shape, bone size, and fat distribution of a female.
What if she decides to detransition and she stops taking her hormone blockers and her hormones and her estrogen? How is the state to police that?
We are a burden on the state does not justify discrimination. If RS did stop taking her hormone blockers and undergo 10 or 2 stage puberty, then perhaps RS would not be able to play on the girl team. However, with the fact under this case, RS has been on this puberty blocker, which would not allow her to undergo 10 or 2 stage puberty. Thus, with the statute at hand, the statute treats individuals like RS and those like RS who have not undergone 10 or 2 stage puberty, the same as Leah Thomas, for example, who has undergone 10 or 2 stage puberty. Thus, this statute creates overbroad generalizations. The statute is also under-inclusive as it prohibits RS, who is similarly situated to cisgender girls, from playing on sports teams. Rather than ensure equal athletic opportunities, the statute does the opposite. As RS, if required to play on the biological male team, would be at a competitive disadvantage because she would be under those hormone blockers and she would not have those driving levels of testosterone to give her a competitive advantage.
So does the standard of review, whichever one you choose for us to consider this under, affect your argument in any way? Does your argument withstand scrutiny or constitutional scrutiny under any of the statutes, any of the standards of review?
Yes, Your Honor, under intermediate scrutiny and rational basis, as using distinctions on biological sex is not rationally related to ensuring equal athletic opportunity, since the differences that create competitive advantages are testosterone. Thus, for the foregoing reason, this court should affirm the 12th Circuit's decision. Thank you.
Thank you. Thank you very much.
Could you advise us how much time she's reserved for rebuttal?
Yes, Your Honor, the petitioner has to serve 1 minute per rebuttal.
Thank you very much. You may begin.
1 point on rebuttal, Your Honors. As Your Honors noted, this court has spoken that there are inherent differences. Under Title IX, with the Equal Protection Clause, states are not required to ignore those differences when the Title IX regulations and this court's precedent acknowledges that legitimate state interests. The state has to consider all students, meaning all transgender girls who may or may not have gone through puberty and who may or may not have been on hormone therapy. Looking at sex at birth provides states with a workable, objective, and reasonable way to ensure competitive fairness that aligns with this court's precedent under Title IX and the Equal Protection Clause. Therefore, we respectfully request that this court reverse the lower court. Thank you, Your Honors.
Thank you very much. This matter was submitted, and will be in, are we going to adjourn?
Yes.
We'll be in recess until.
Thank you to the justices. This does conclude the oral argument portion of the final round of this competition. At this time, the justices will proceed to their chambers to finish filling out the score sheets. Once they conclude with the score sheets, they're going to return to the courtroom and begin with the critiques at that point.
All rise. Or family, maybe it's
Unbelievable. Oh, please.